Please be seated. We are here this afternoon for three cases. The first case of Nathaniel Olson versus State of Iowa is hereby submitted without oral argument. The second case is State of Iowa versus Jesse McCullough, also submitted without oral argument. Our oral argument for this afternoon is Goche. Is that how it's pronounced? Goche? Okay. Goche versus Kossuth County and Bolton. I understand Mr. Voss will be arguing for Goche. And I also understand perhaps two people are going to share time? Is that correct? Yes, Your Honor. So Bob Goodwin and Jeff Coleman will share time?
Will be arguing on behalf of Bolton Mink. I'm Jeff Coleman representing Bolton Mink. We both are.
Okay. So I'm sorry. So your name is Jeff Coleman?
Jeff Coleman.
Okay. Right. And then you, sir, are Mr. Goodwin? I am. And you'll be arguing on behalf of Kossuth County? Who's going first? Are you going to argue? And then I'll let you guys split your time between the two of you. We won't separate it on the clock. Okay? All right. Mr. Voss, you may begin.
May it please the court, opposing counsel. This case is an action for punitive damages against the supervisors in control of various drainage districts in Kossuth County. The petition alleges that the defendants have intentionally misused their authority to cause financial damages to the plaintiffs. District court erred in dismissing the case. District court got hung up on labeling the nature of the defendant's liability and failed to recognize that liability exists under either Iowa Code Section 670.12 or Iowa Code 468.526A. Those two statutes are mirror images of each other. 670.12 deals with the liability of officers and employees of municipalities under the Iowa Municipal Tort Claims Act. Iowa Code 468.526A is found within the drainage district statute and deals specifically with trustees of drainage districts. But they state the same standard of liability. Each says that officers and employees or trustees are not personally liable for claims which are exempted under 670.4 except for claims of punitive damages. And then they...
Your argument by stating this is a claim for punitive damages. And as I read your brief, you're really not making a fiduciary duty argument anymore. And correct me if I'm wrong, but you seem to be arguing that there's a standalone claim for punitive damages that's authorized by statute. Is that your argument?
Correct. The petition did speak in terms of fiduciary duties, and in some ways that's very logical because the term trustee is by nature a fiduciary role, and so that was how the duties were couched. As I stated, I think the district court got hung up on that label when the nature of the case was to say, when you look at the statute, and we specifically cited 468.526A, this is a claim for punitive damages under that standard.
Would you acknowledge then, in our case law, we've said that there is no standalone cause of action for punitive damages, that punitive damages are incidental to a recognized cause of action. And so your argument is that this is kind of a statutory punitive damages claim rather than a...
It's a statutory punitive damages claim because the claim for actual damages is precluded by the language of 670.12.
Right, but I guess I'm getting at, under our case law, outside of this statute, we have not recognized an action, quote unquote, an action for punitive damages. So how do you address that case law?
I think the way I would address it, Your Honor, is to say that there are statutory duties that 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 the board that is in charge of a drainage district has, whether it is private trustees or a board of supervisors. And those duties principally relate to how they classify land and manage the district. But those duties, when they are intentionally violated to cause financial harm to someone, gives rise to a claim for punitive damages. So I would say there are statutory duties that were not met here, and that the intentional nature of that misuse is what gives.
Juries. That the willful, malicious nature of this gives rise to a statutory punitive damages claim. Okay.
In looking at the statute and how it should be interpreted, I think we start with 468.526A to say what was the legislature trying to accomplish here, because that statute is of relatively recent vintage. It was passed in 2014, and it deals explicitly with trustees of drainage districts and says that they are not liable for actual damages, but that they are liable for punitive damages. And so anticipating an argument by the Board of Supervisors, since they have claimed in their brief that essentially there is no liability of any sort for a drainage district, and that immunity then adheres to the trustees of it. If that was the case, then 468.526A is completely unnecessary. That is, there would be no circumstance in which trustees would ever be liable, and you wouldn't need to adopt a statute that immunizes them if they automatically are cloaked with the immunity of the drainage district itself. And so giving effect to the statute is accomplished by saying that we read it in connection with 670.12, which it was modeled after, and say previously, since the adoption of the Iowa Municipal Tort Claims Act, the supervisors in that capacity were either liable or not liable to the extent that 670.12 said, and now 468.526A adopts that same standard for the trustees.
A little bit this, notion of punitive damages that, that you can pursue sort of kind of punitive damages without having a recognized underlying claim that can go forward for actual damages. I mean, you would agree your argument applies to things that a board of supervisors does generally. It wouldn't be limited to drainage districts, would it?
Sure.
It would apply to all kinds of local elected bodies. And so wouldn't this sort of just open up, the doors to any kind of citizen suit against their elected body, or, the elected body for that municipality or that school board or that whatever, whenever they didn't, agree with a decision and felt that the people were acting maliciously towards them? They're elected representatives. I mean, it seems like an odd kind of tort liability.
Well, and thankfully, I think our boards and our elected officials are not generally acting intentionally to harm people. And so, but what's the
question is, in this sort of litigious era that we live in, doesn't that open the door to a lot of lawsuits? I mean, I always thought your main remedy against supervisors is you vote them out if you don't like what they're doing.
And that would be a fine remedy if they haven't caused you damage specifically. And that's what I think is unique here, is that the allegation is that they intentionally caused financial damage to to my clients. A lot of the things that supervisors or do, one, are going to be addressed by the actual immunities in 670.4, but also may be addressed by the public duty doctrine, if it's a, if it's sort of a discretion, ordinary weighing of different courses that are available to it. But I think when you look at 670.12 or 468.526A, I guess where I would disagree or at least push back a little bit on where you're going is there has to be some subset of activity to which this applies. That is, it states that there is liability that's available, for punitive damages. And so it can't be that if the underlying action, I guess, I think if you take your point to its logical extension, what is the subset of activities to which this statute applies? Or are we just dealing with an empty set where there's...
You're right. No, it's good. That's a fair point. I suppose if a drainage district trustee went to a farmer and tried to shake him down for a bribe, and the farmer was forced to pay the bribe and then wanted to sue over that individual later over that might be a situation where the claim is not foreclosed and the punitive damages would be available. I'm just thinking out loud. Let me also ask you about, if I could, about the other argument that's raised by the other side. I actually think the district court might have been right in its initial order about 46896. It seems like most of the things your client is complaining about generally have to do with sort of assessment decisions, things that your client would otherwise have had the ability to, in effect, go forward with a judicial appeal of the decision made by the drainage district. And why isn't that the exclusive remedy under 468.96? It seems many of the things you're complaining about strike me as of that nature.
And I guess the sort of the twofold response would be, one, Judge Sandy reconsidered that, and it's not, there was no cross appeal on that basis. So
on a ground, whether the trial court relied on it or not, as long as it was raised below and the parties had an opportunity to litigate.
Thought or consideration is that remedy does not, there's no procedure there that involves these defendants. That is the appeal or mandamus, that would be a remedy that would be asserted against the district itself. It's not a remedy that exists against the supervisors in an individual capacity. And so that's the distinction that I would make, and I think that's why Judge Sandy in part revisited his ruling.
Can I take you back to your discussion about what subset would be left in 670.4? So 1E specifically just immunizes the municipality for any claim for punitive damages. And so is that what 670.12 might be referring to? Is that when you've got a claim and it includes punitive damages, whereas the entity might be immunized for punitive damages, the individual is not?
when we're dealing with, I guess, intentional torts, if just drawing a contrast between that and what I would consider to be negligence-based torts. Negligence-based torts are very, you have duty and breach, and those are fundamental considerations. With an intentional tort, we typically don't ask about the duty in the same way because it's understood that we have a duty to avoid intentionally harming other people. And so while I would agree that it's a possible reading to say 670.41E exempts out the entity, and 670.12 exists to create it against the individuals. I'm not sure, I guess, also that would carry through to 468.526A, which I guess leads to the question as to whether we should be interpreting the identical language, same place, both places. So.
About your claims against Bolton and Menk. Excuse me. As I read your brief, there's really nothing that's addressed to the claims against Bolton and Menk. Are you waiving those?
Your Honor, and I see that my time is up, so I will be brief on this. The dismissal as to Bolton and Menk in of the aiding and abetting claim was just to say, since we find no duty on the part of the county supervisor defendants, we're going to dismiss aiding and abetting. So I think it's just as simple as saying, if we've got a viable claim against the county, we adequately pled aiding and abetting. We pled that they knew that the reports were false and they were going to be used for an improper purpose.
Direct claims for breach of fiduciary duty and conspiracy.
Those are gone.
Which one's first? We're going to have Mr. Goodwin first. All right, there's 15 minutes on the clock, and you two can decide when you're going to hand it over to him. Thank you.
May it please the court, counsel. The Goches are landowners in drainage districts in Kossuth County, and they want to seek punitive damages against the Board of Supervisors on the basis of a fiduciary duty. The district court correctly ruled that there is no case law, no statute that imposes a fiduciary duty on a Board of Supervisors to a landowner in a drainage district. Actually, the Board of Supervisors have a quasi-judicial function. They don't have a personal relationship with anyone in the drainage district to act on their behalf or give them advice. Instead, again, the board has a does not have a fiduciary duty. Instead, the board has a quasi-judicial manner. The board appoints an engineer to look at an issue, to prepare a report, to make a recommendation. The board has a public hearing on that matter, and they get public input. The board then makes a decision as to how to proceed in the management of the drainage district, and that decision can be appealed. So again, the board has a quasi-judicial function. It doesn't have a fiduciary duty to a landowner. The brief of Goche's says that they don't have to establish a fiduciary duty to make a claim for punitive damages. However, their own motion for reconsideration rebuts that. Their motion states, punitive damages cannot be a separate theory of recovery. Punitive damages are merely incidental to the main cause of action, and they are derived from the underlying cause of action. There is no fiduciary duty. Therefore, they have no claim for a punitive damage in this case.
Mr. Voss's argument about the empty set, if we were to read the statute in the way you're suggesting, then it really doesn't apply to any claim.
The big things that they miss is the case of Fisher versus Dallas County. Says that the drainage districts and the Board of Supervisors managing them are not susceptible to a claim for money damages. That same case also says they're not susceptible to a claim under Chapter 670 because they are not a municipality. The argument that 468 526A is applicable is incorrect. That statute does not apply to a Board of Supervisors. Drainage districts are established by a Board of Supervisors, all of them. However, under Section 468.500 and sequence, the management of the drainage district can be transferred to actually 3 people in the drainage district who are owners in the drainage district, elected by the drainage district, and named trustees. So Section 468.500 and sequence, and particularly 468.526A, does not apply to the Board of Supervisors. It applies to 3 landowners elected by the other landowners in the drainage district to serve as trustees.
But you have the same exemption for punitive damage claims in the Municipal Tort Claims Act. So, you still have the empty set problem, don't you, under your theory?
What I see is the case law, Fisher versus Dallas County, establishes that a drainage district and the Board of Supervisors managing it are not susceptible to a claim for money damages. And it specifically says they are not also subject to a claim under Chapter 670.
Of claims statute or 670 apply to? Give me an example of a cause of action. If Mr. Voss is wrong and this doesn't create a standalone claim for punitive damages, tell me when it would apply. Like, what's an example?
468, 526A, and all of 468, 500 and sequence do not apply to the Board of Supervisors.
Let's assume this is a board of trustees, the 3-person elected. Just give me the name of a cause of action that would apply under this statute.
At this section, and actually they quote, what was his name? Dave Maxwell as saying the trustees are not the Board of Supervisors in this section, 468, 526A. And actually, it appeared to me that...
Question real quick. This is a really simple question. I understand your position that this doesn't apply to this particular set of defendants. Let's assume it did. What is the name of the cause of action other than Mr. Voss's standalone punitive damages claim to which this would apply? Like, I just want a name. Like, what is the legal theory that this applies to?
Well, actually, I don't see that this statute applies to anything because I think Fisher versus Dallas County prevents a claim.
It does seem to me, Mr. Voss is sort of maybe edging towards this point. He and you seem to be in agreement you can't have a fiduciary duty claim. But that wouldn't preclude some types of intentional tort claims. I mean, you know, I don't know a fiduciary duty to you, but if I came down from the bench and slugged you, you could sue me, right? I mean, and similarly, a board of supervisor or in the elected situation, a trustee might not owe a fiduciary duty to a landowner, but if they, you know, literally opened up put a hole in some levee or dam or something and flooded their field, intentionally, they might be able to sue that person, right?
I see the Board of Supervisors in a quasi judiciary situation. You say if you would damage someone individually, I think what that is would be an assault, but not a fiduciary duty. I agree. And so when I was looking at this, I thought it was very peculiar that they even passed this statute, 468-526A, because they apparently were not aware of Fisher versus Dallas County, which says a drainage district and when it's managed by the Board of Supervisors are not susceptible for a claim for money damages, and specifically are not liable under Chapter 670. 468-526A talks about that Chapter 670, but I think the authors of it were not aware of the decision in Fisher versus Dallas County. So what I would think, I would think there would be a good argument that there's no liability even to private trustees under 468-526A. I think I have to give the rest of my time to counsel for Bolton and Mink, but I think the biggest thing that Goche's miss in their brief is not recognizing the immunity of drainage districts from a claim for money damages and even a claim under Chapter 670.
Coleman? Is that right? Are you going to be the next one?
No, my partner, Steve Buterin.
Okay. Okay, I don't have his name on my list, but okay, thank you. In the microphone?
Stephen with the PH, Buterin, B as in boy, Uterin. And I was just admitted ProHack, I believe it was on Saturday or Monday. So it's happened very quickly. So, thank you, Your Honor. May it please the court, counsel. My name is Steve Buterin, and I'm here on behalf of Bolton and Mank. And given counsel's apparent concession that they are letting go all of the claims except the aiding and abetting, that's shortened my argument considerably. I think we join in and adopt the arguments that have been presented by the Board of Supervisors. And the one issue I would just point out to the court that hopefully the court doesn't have to address is that if the court chooses to look at the issue of whether engineers have a fiduciary duty in this context, and that's an issue that is quite significant to all engineers in Iowa, because it presents an insurmountable conflict between the engineer having a fiduciary duty and an engineer who has the ethical obligation under the rules of conduct to protect the safety, health, and life of the public. And the two cannot be reconciled. So in light of that, we would kindly request that the court rule in favor of Bolton and Mink and affirm the district court's decision that ruled that Bolton and Mink did not have a fiduciary.
So if the liability against Bolton Mank at least rises and falls with whatever claim that the plaintiffs can assert against the Board of Supervisors and former supervisors. What is your answer or response about this standalone punitive damages claim or statutory punitive damages claim and the empty set problem we've been discussing?
I would say that in terms of, well, in this case, there would need to be some underlying conduct by BMI that was sufficient to allow for a claim of punitive damages. And in this case, BMI simply prepared a report and gave it to the Board of Supervisors, and I guess the way we view it is there's no underlying wrongdoing that would give rise to a claim for punitive damages. We simply were performing what we were retained to do for the watershed district, and there's no evidence that would, no egregious conduct that would support a claim for punitive damages. Thank you.
Ross.
Just briefly want to touch on Bolton and Mank. And I don't think I get, it's like 15 more minutes. I didn't think anyone wanted to hear me talk that long. So in part, Bolton and Mank's argument is more of an argument to a jury than it is a motion to dismiss argument, at least as it pertains to aiding and abetting, because what was pled, and Judge Sandy paraphrases it succinctly but well in his ruling, is that that one of the Board of Supervisors caused the trustees to hire Bolton and Mank to prepare a report falsely demonstrating that plaintiffs tiled illegally. The trustees did so with the specific intent to force plaintiff to remove the tile and informed Bolton and Mank of the same. The trustees then relied on the incorrect report of Bolton and Mank to demand that plaintiffs remove the drainage tile, threatening legal action. Bolton and Mank knew the report was being procured and would be used for improper purposes and knowingly participated in the wrongful conduct. So at least as it pertains to aiding and abetting, we have the right standard pled as Judge Sandy characterizes it, that they knew of the improper purpose, and that knowing that improper purpose, they committed an overt act, if you will, that assisted it. And so that is just for the point of saying that they should not get out based on the "we didn't do anything wrong" claim. That's not the motion to dismiss standard. That's an argument to a jury later down the road. With respect to Fisher, we did not ignore Fisher. Fisher says, in part, that the Board of Trustees of a county manage a drainage district in a representative capacity. And so it is true that drainage districts are recognized as, I'll call it like a limited purpose entity, if you will. Some of our precedent, this court's precedent refers to it as a subdivision of the county, but it's not nothing, I guess, as far as being an entity with some existence, and it can be misused. And that's the heart of this petition, is to say there were people in charge of managing this, and in that capacity, they actively misused it for the harm of the plaintiffs. I don't think Fisher dealt with that situation. Fisher certainly creates, is a statement with respect to the drainage district's liability itself, but it does not deal with the liability of the managers of that drainage district intentionally misusing their power to harm other people. That's
All right. The matter of Goche versus Kossuth County and Bolton and Mink is hereby submitted, and court is adjourned for the afternoon. Thank you.